Okay. Does that work? Is that weird?
Yeah, no, that's good.
It's weird in my ear, but all right. And the clicker. There's Gary's. It's not just me. It's my husband, Gary. FYI, we aren't in business together, but we're together in business. I don't know. He has a downstairs office. I have an upstairs office. We eat 3 meals a day together. We share stories. I won't say what kind. Interesting stories. But because of the state bar, I can't represent him or represent clients that he's working with, but I can refer him and then I step back, whatever. We work it out. We follow all the rules. So I started out going to law school and then became a mom. It happens, right? And one thing led to another. I only worked for a couple of years, became a mother, then stayed home for quite a few years and really enjoyed every minute of it. Maybe would have enjoyed 15 more years of earning money, but whatever. So I know a lot about kids. I know a lot about organizations, PTA, that kind of thing. And having already gone to law school, my interest was always in estate planning. The idea being that you draft a nice, clean document, and if things go haywire, someone else takes care of it. That is so not the way estate planning is, because whether I'm in court or not, everyone's life is in haywire, is crazy at some point. And we're all given challenges one way or another. So if you think whatever you're experiencing, and probably you don't because you're in this group, is unusual, different, undeserved, well, of course that, every single family, there's some pretty good families, but everyone has challenges and nothing surprises me. There's nothing to judge. Life is crazy and it unfolds. So let's talk about putting a little plan in your life. Estate planning, Bev asked me to talk a little bit about estate planning, not just special needs planning, which is key because estate planning is the foundation for special needs planning. You're typically, you can be planning for today. Most families are planning for their disabled children or even adult family members somewhere down the line, particularly when they have passed away. Parents of young children, minor children with issues, be it learning disabilities, whatever, you're the walking, talking special needs trust. You're taking care of everybody's needs. But just like any caregiver, if a caregiver doesn't take care of themselves and they become ill, then they can't take care of whoever they're caring for. So one thing that you want to take care of is your estate plan, so that if something happens to you, there are mechanisms that will, I don't know, they'll jump into place, but they'll be there for everyone to rely on. So the main benefit of doing estate planning now is you get to decide who's in charge of your assets and your well-being when you no longer can do it. Yeah, you name your wife, but what if you both get in a car accident, whatever? You can say you can nominate who you want to take care of your children. You can nominate 1, 2, 3, 4, and whether they handle the child or just the money. If you don't do that, then someone has to come forward. The court has to look at this. All nominations for children guardians are approved by the court, but they look at what you say. And then lastly, your will or your trust will dictate where your assets go at your death and how they are handled. So this is a basic estate plan. I think if you don't have it already, initially all you need is a basic estate plan. If you have tens and tens of millions of dollars, you shouldn't be listening to me. You should have already talked to your lawyer. So, oh well, we can start here. A will or a trust, in this area, it's usually a trust and a will. I'll tell you why a little bit later. Powers of attorney for finance, advanced health care directive used to be called a power of attorney for health care. You need to look at your retirement beneficiaries. You want to make sure you name who they are. And the same thing with your life insurance. All of those things represent your assets. All of those things consist of your estate, and if you had enough money, all of those things are what the IRS looks at to decide whether you need to be subject to estate tax. But I'll just throw in now, we each are allowed to pass along over $11 million each, both you and your spouse, down to your heirs without estate tax. That number is really huge right now. We don't even think about it for most clients. They say in 2026 they're going to drop it back to 5 million each. You know, who knows? I'm going to get water. So that's all, you know, it's not everything to think of, but it's most things. So let's just talk about a will. A lot of people think they only need a will. And if you have a small estate, that may be the case. You use a will to nominate guardians for your minor children, and you say where your assets are going to go. You could even put in there that at your death, poof, a special needs trust or some other trust comes into play, and the money that your executor garners from your estate will go into that trust as the will says. So they can work. But if your liquid assets exceed $150,000 and or your real property exceeds $20,000, your estate will go through probate. If it's under that, there's a way to distribute those assets by declaration and stay out of the court. But this, you're going to have to go to court. The court's going to supervise collection of your assets, accounting, distribution. It takes time. There's filing fees. You do need an attorney, but you need an attorney usually. But the fees are set by probate code, California state law, and they're rather high. So just for an example, $1 million estate, your house, your life insurance, your retirement gets to $1 million, can get to $1 million pretty quickly. The fee for just the attorney is $23,000. And on top of that, your executor, if it's not maybe a family member, can charge an equal amount, and the court will approve those fees. Everything that you submit to the court for approval is made public. Anyone can go in there and look at that. Your heirs are going to start getting phone calls. And the court is, you know, you have to wait every 2 months to get on court. You need a couple of different hearings, and it can cause delays. It doesn't always. So if you have a very contentious family and you're gone, make them go through probate. One way to get back at them. So if you have no plan, no will, no trust, you have very little control. You could have a bank account that you have a pay on death beneficiary. I die, it goes to my friend John. That works, there's no probate on that. But if you don't do that, you don't have a beneficiary in your bank accounts, then your estate likely will go through probate. And the state probate code, it's a section of codes that say, if you die, your assets are going to go to your parents or to your spouse and then to your kids, if no kids, to your siblings, and it's all laid out. It's not your friend or your niece or your godchild. It's not going to go there. If your children are young or youngish, they're going to get it. They're going to get all that you've left to them at 18. Maybe that's not a good idea. And someone from your family or whoever has to come forward, file a petition, ask to become the guardian of your children if you die when your children are young. Then the court will look into them and decide your nomination isn't on there. Your suggestion of who you want isn't going to be considered because it's not in writing. So that's easy. So I'm going to jump right into trust planning. This is not going to be an exhaustive estate planning seminar. I'm not going to use any acronyms except for special needs trust. I'm going to maybe use SNT. It's the only one. There's lots of different trusts. So a trust is a contract, and you have to have the capacity to sign a contract to sign your trust. What it is a contract, and let's pretend it's in the shape of a bucket. And you're going to take all of your assets, your house, your furniture put it in there physically, and your bank accounts and your investments, and you're going to put them into your trust. You're going to retitle them into your trust. Then those assets are going to be governed by the terms of your trust contract. And it's a contract between you, the creator of the trust and the owner of the assets, with yourself as the trustee. And the trustee Their only job is to manage the assets pursuant to the trust terms. So initially, if it's you or you and your spouse, you're the owner of the assets, you're the creator of the trust, and you're the trustee. You're making a contract with you, yourself, and yourself. And as long as you're alive, you manage your assets just as you would normally. And most of a trust document, if you've ever seen them, they're 20, 30 pages. Most of those pages provide terms for you to manage your assets exactly as you do it now. It's giving you the freedom to take care of your assets. You as the trustee, if you're not the trustee, someone takes over for you because you can't do it, they have to follow the trust, and they have lots of rules, and Barry's going to talk about those. But typically, it's you or your children or your spouse. So put it in there. You get to name your trustees. The court doesn't manage it. You get to name the alternates. You put in your distribution plan, just like the will, where things go, where they don't go. Anything in the trust will avoid probate. So it's not public, typically can go faster, and you're going to hope your fees are less than probate. Depends on your attorney. No. So then you decide, and your will is out there. The will is the little toe of estate planning. If for some reason you don't get all of your assets titled in the trust properly, they may have to go through probate and follow the terms of the will. The will says once it's been probated, there's a term in the will that says all those assets will be governed, is this working? Governed by the trust terms. So it's called a pour-over will. All the assets pour in there. There are some little ways in between to avoid even doing that if you have a trust in place. So then you decide where are things going to go. Outright to your children. If we're lucky, your children are 40, 50, 60 before you pass away, right? Maybe older. Hopefully they can handle the money. It goes to them. Thanks, Mom and Dad, I can retire now. Yay. Or thanks for nothing, Mom and Dad, whatever. So you can do that. Or you can, at that point, have a trust sitting there waiting to be sprung into action. And it can be a special needs trust. We'll talk about that. Or any other kind of a trust. If your child doesn't have any disability other than they're spendthrift and you don't want the money to be gone in 3 months, you can appoint someone else to be the trustee and have the terms of the trust say they only get income or an annuity amount or a set amount or increments at a certain time. For a good child, I don't want to say good, for a child who doesn't have any major issues, you can set up a trust where, in fact, my children are bad sometimes. You can have a trust where, when they're old enough, they take over management of their own trust. The money is not their money. The money belongs to the trust, but they get to control it. And what that means, because an inheritance is their separate property, one thing that it means is that if they get divorced down the line, if the funds are still in that trust, it's not subject to a divorce split. It used to mean that for generations up to a certain amount of years, the assets in there and the appreciation up to a certain amount will pass down to their children and to their children and escape estate tax, where the child and their spouse may be dual income earners with lots of stock and have enough money to be subject to estate tax. Let's say if it goes back to $5 million or something. But this money, if it's still there, will pass down without that. So it used to be a strong estate tax tool. Because we each have 11 million, that's 22 million together. Maybe we don't need that so much because maybe no generation's going to get hit with estate tax. Hard to know. But they can deplete that trust. If you have a child who's a spendthrift and is going to go through bankruptcy, you can have that trust for their benefit, but you don't want your child to be the trustee because then it loses creditor protection. So it also can be protective from creditors. So let's move on. You got it so far? It's pretty basic. Maybe 90% of you already have this in place. Let's hope. So beyond that, these are the other two key documents that I recommend that anyone 18 years or older have. You have to have capacity to create these documents. The capacity to do a power of attorney for healthcare is a bit lower than for a power of attorney. So you can, if you know who you, if a doctor or someone can determine that you know who your parents are or who you trust, then they can write a note to say they have capacity to do this. Power of attorney is a little more complicated, but I made my kids do it. We put Gary and I on there when they were young, and they said, "Do we have to appoint you?" And of course we said, "No, you can erase it, put whoever you want on there." And they said, "Okay, fine, just leave it." Well, in the meantime, they went to Indonesia, they went to Prague, they went whatever. I forgot to send my transcripts. I forgot to send my healthcare record to the college. Can you do it for me? Well, we wouldn't have been able to, except that we had these, and they were recognized, and we took care of everything. It was their job, darn it. All right, so I'm going to go through this. I'm going to be like the ladies up here. Who does not have an advanced healthcare directive? Be honest. Okay, hardly any. Oh, wait. Well, just a tiny bit of you. Go home this week and do one, okay? Promise? Yeah. All right. So in this document, you're going to name who's going to make healthcare decisions for you. Typically, they don't have that power until a doctor says that they can no longer communicate with you. Once he says that, then your agent steps in, they make the decisions. And you can guide that agent by saying what your preferences are. If in fact, under all circumstances, you want everything to be done to keep you alive, you can say that. And you can almost hold your agent to it. I generally recommend that you put in your preferences, that you leave the final decision to your agent, because you don't know what all the circumstances are. Your agent can get 1, 2, 3, 10-second opinions before they make a decision. They can wait 6 months. If you're in a coma, you're on life support, even though they know you want to die today, they can delay that decision. Maybe they need that to make themselves feel better, other family members. Maybe they're going to do exactly what you want because you've been very clear about what you want. They can make that decision guilt-free. So if that's what you want, this is the place to do it. And they can get, if there's proper drafting, they can get authorization to your medical records under HIPAA. Maybe you guys have heard about that, health insurance portability, privacy and portability. Anyway, you can't even with a basic advanced healthcare, you can't get somebody else's medical records without them first signing a waiver. So you want that waiver in there somewhere. So the bottom line is, if you don't have an advanced healthcare directive, then and the doctor or the hospital isn't looking to the next of kin. They do sometimes, parents, spouses, to what do I do? But if two siblings or two children are saying, keep them alive, don't do that, yes, do that, then the doctors and the hospital step back and say, go, you don't have this paper, so you need to go to the court and to get yourself appointed conservator, which gives you the power to make those decisions. So that causes delay. General power of attorney, I'll just tell you that same thing happens. If you need a power of attorney and you don't have one, you're going to go to court. The trustee manages all of the assets that are in the trust, but there are things that can't be in the trust. Retirement accounts, insurance policies generally aren't. Maybe you have a bank account that you didn't put in the trust, even though it would be my recommendation to do it. If you don't have a beneficiary, if you're alive but you can't manage it, you need to get access. Maybe your child who created a bank account and didn't put you on as co-tenant, which isn't necessarily a good idea, and they get into a car accident and they got a car payment, and you need to get access to their account. You won't be able to if you don't have this. So this person can have access to assets not in the trust. They can sign contracts on your behalf. They can hire lawyers if somebody gets you in a car accident and you need to sue the guy. Your attorney, in fact, under the power of attorney, can sue, can hire a lawyer. This terminates at your death, doesn't have any power once you die. And you can put other things in a power of attorney that need to be specially drafted from the standard form, such as gifting, which could be important for public benefit purposes. All right, Now we're going to move on. You've got your trust. You know that if you feel your child needs special needs planning, then we're going to talk about when and why and who you would do that. Okay? So why consider special needs planning? Well, to protect and manage resources for individuals with disabilities without sacrificing government benefits or entitlements and to qualify for certain supportive services. So generally, we're talking about SSI and Medi-Cal. You may have SSDI and Medicare and Medi-Cal. There's more than one way to get to Medi-Cal. SSI, maybe you know, supplemental security income is when you become permanently or disabled enough that the state of California says you're disabled and you have not worked and paid into our Social Security system, then you qualify for SSI. Because you haven't worked, you haven't paid in, you have to meet a standard. You can only have $2,000 of assets and very low income. Medi-Cal is similar depending on how you get it. Now we have the ACA, the American Care Act, Obamacare, as we call it. Sometimes Medi-Cal will pay for your insurance because you have low assets, and that's it. Low income. It's based on income only. You can have as many assets as you want. It's a little bit different. So I'm not really going to talk about Obamacare. I'm talking about being disabled, not just poor. Basically, you have to be poor when you're disabled to get benefits. It's kind of a weird concept that someday we'll get around. So maybe you are parents of a family member with disabilities who is either receiving or you think will need public benefits that will be useful to them. Disabled adults, maybe you're one of those people here today who you have too many resources to qualify for public benefits, and you're going to need them. Or you're not sure you need them, you might need them, but you are disabled. And then I'm just going to mention this. If mostly we talk about it with elders, but I've had young clients who come down with MS, something like that, and they end up in a skilled nursing home because it's so severe they can't be cared for at home, or there are now waivers you can get nursing care in the home, but that's been a new thing over the last 15 years. You may need to go in a nursing home. Nursing homes cost $8,000 to $12,000 a month. Medicare pays for 30 days or 100 days, then you're on your own. There is no automatic payment, but you can qualify for Medi-Cal to pay for this. It's a little bit different, but it's a needs-based thing again. You can only have $2,000. Your spouse can have $123,000. Your spouse can have only so much income, a little over $3,000. Anything over that in income, you pay to the nursing home. Anything over in assets, you're disqualified. But with proper planning, you can make it so that you can preserve some of those assets for the well spouse in such a way that we don't impoverish the well spouse. All right, so like I said, it could be important for those on SSI, Medi-Cal, veterans benefits, Section 8 housing. SSI and Medi-Cal are needs-based, so that has the asset limitation. Veterans has an asset limit. They're very vague about what that is, but they do. SSDI, you pay into that, you become disabled, you can't do substantial work, you can get SSDI. You can keep all of your assets, no problem. But if you're on SSDI, you're not working, you're not getting a work-based healthcare plan. Maybe you can afford a healthcare plan, maybe you can. If you can't, then you gotta wait 2 years, then you get Medicare. Why you have to wait 2 years is another one of those, it's a financial decision. We're gonna pay for some things, but not others. You can get a heart transplant, that you've gotta wait 2 years for your Medicare. But Medicare has copays. Maybe because you haven't worked, you've lost your money, blah, blah, blah. You might need Medi-Cal to supplement that. So, and another thing, so unless you really need those benefits and depend on them, you don't really need special needs planning. You've got money. Another new thing out there is ABLE account, which might be enough for some people. All right, let's talk about special needs trusts. So we know We know a trust is a contract. In this situation, you yourself as an adult disabled person can create a first-party trust. You can do it. It's sort of a contract with yourself in a way, except that you cannot be the trustee. There's pooled trusts, which are similar, and they are run by nonprofits. And third-party trust is the typical parent creates a trust, their money goes into it, or a grandparent, or a really good friend. I don't have any of those. Okay. So let's talk about a first party. So if you are a disabled adult and you get money, maybe you get a lawsuit payout, maybe you get $20,000 from your grandmother, maybe you find a case of money on the street. Anything over $2,000 is going to kick you off your SSI if you're on SSI. Or your Medi-Cal. So we're assuming you need public benefits when you're doing this, or that you will, yes. So, I'm not sure what my last sentence was. I'll have to start from the beginning. No. First party trust, disabled individual who is on, I'm going to sort of assume, I'm going to talk about the highest situation use. So someone who's on SSI or Medi-Cal is disabled. They're on a needs-based program. They can only have $2,000 to their name in order to keep their benefits, as small as those benefits are. But they come into money. They inherit it. They win a lawsuit. They find it. I don't know. Depends on how much. If it's a little bit and you can spend it the month you get it, you're okay. If you spend it on a car, you're allowed to have a car. You can spend down that money. But if you don't need to buy anything and you kind of want to save it, you can use an ABLE account, and we'll get there, or you can create a trust for yourself. It used to be until just a year and a half ago or 2 years ago that you then had to have somebody go to court on your behalf because the laws were drafted that you had to, if you had a disability, they presumed you were mentally incapacitated. Left out a whole bunch of people who aren't mentally incapacitated. But now you can do that. You can go to probably an attorney, get your trust drafted, and you can put the money in there and use it in ways that don't interfere with Medi-Cal or SSI. And we'll talk about some of those rules. It can only be used with the disabled person's money. You typically don't mix it with other people's money. If you're a minor child, or if the person involved is disabled and doesn't have the capacity to do this on their own, then you're going to need a court order. The one bad thing about it is if you collect Medi-Cal benefits from Medi-Cal, the state of California, age 55 and after, at your death, the state has a right to ask for that, whatever they've paid on your behalf, back. If there's anything left, it'll go wherever you, the disabled person, says it goes, to their children, wherever. And you have to create this before you're age 65. Did I answer your question? Okay. All right. Well, we'll stop in a minute for questions. So a pool trust is similar to a first party. Actually, anybody can do this pool trust. You as a parent can put money into this, and a disabled person can too. The nice thing about a pool trust is if you have a very little bit of money and you can't be the trustee, there's a trust within the nonprofit who the trustee manages it. If you were to hire a professional, a bank or Gary or someone like Gary, they typically want a certain amount of money in there so that they can invest it and at least cover their fees. At some point, it just seems too small to deal with a trust, pay for a trust, all that. Setup fees on a pool trust are a little bit lower. They still charge money, about $1,000, I think, to get you started. And then they take a monthly fee. Again, the state needs to be reimbursed, although they're wishy-washy with these trusts. These trusts have finagled and they say, no, we're going to keep it. We want to keep it. And we're going to use it for other disabled people. So the state maybe doesn't take the claim. And some trusts will allow you to name beneficiaries. They're all over the map on that. And the other good thing is you can be over 65 and create this trust. Yes.
So, I think if I understood your last sentence correctly, that disabled person who would be a beneficiary of one of their clients
Right.
could potentially receive more money than was in this part of the
No. So actually, when you put your 50,000 or whatever in there, they keep separate accounts.
okay.
And if you don't use all that 50,000, then they put it back in there, and they don't really, they put it into their endowment pool to generate income. I don't think it really, it might increase the income because it stays in the endowment pool for investment. I don't think it really goes out to other individuals, and it might pay for overhead. It's a good question, though. But if you put 50 in, you're only going to get 50 plus interest out, less fees. Yeah. Okay. That's what I think. Yeah.
So, if say the child, that's a good amount, and he dies before he chooses, that's another matter.
It depends. If are you talking about a pooled trust or like a first party? Well, that's okay. Except for the pooled trust, a first party or the next one I'm going to talk about, whoever created the trust gets to name who the beneficiary is.
How many pool trusts are there in California?
I'm going to say less than 20, less than 10 maybe. There's Good Shepherd is one that, but
They're relatively rare.
yeah, I mentioned Good Shepherd because they have an office here, but they're actually based in Colorado, and they cover a big part of the country. There are others, and you can go online and get a list of all the California pool trusts very easily. There is some discussion about whether they're viable with their investments by how many people use it, who's managing it. So, sort of like our banks, our insurance companies, a little bit of risk there. So we talked about first party trusts. It's your money if you're the disabled person. There's a payback provision. You have to do it before 65. Pooled trust, you don't need a lot of money. Nonprofit handles it, and you can be over 65. The last one, the most common trust that I draft is a third party trust. Third party means it's somebody other than the disabled individual who creates and funds this trust. So it's typically parents, grandparents. So you can create a trust right now, put money in it. You can be the trustee, somebody else can be the trustee other than the disabled person, and start using it for a disabled person. Not everyone wants to do that. They want to wait till they die before they allocate these funds. They just want to manage it themselves. So as long as you're alive, whether your child is a minor or an adult, and you're helping them, you're the trust. You just don't have any paperwork. You make all the decisions. You give the money any way you want. Or you can wait, have it draft so that your will says upon your death, disabled child's money goes into a special needs trust. The good thing about this, it's not the disabled person's money, it's your money or a parent's money. So there's no payback for whatever Medi-Cal has paid for this person. Anything left over goes to wherever the creator says. So it could go to the children of the disabled child, it could go to your other children and go to charity, whatever you want. And you could have, so if you create it, you're the parent, you get all your ducks in a row and you create this trust, but grandma says, oh, I was going to leave your child $50,000. They don't need to create their own special needs trust. If they're happy with the terms of that trust, the attorney can simply provide their attorney with the name of the trust. So their trust says, or their will says, at my death, $50,000 shall go to the trustee of this special needs trust, and another $50,000 gets put in there. Yeah. So taxes there are, so hey, it's the IRS. If your trust makes income, there will be income taxes to pay. And you can have the trust pay it, but if you get to just a few $1,000s, the trust income tax level goes up, the bracket jumps really high right away. If the income is distributed to the beneficiary, hopefully in a way that doesn't invalidate their public benefits, then the disabled beneficiary will report that income on their tax return, and they're going to be, theoretically at a much lower rate than their parents. Comment? Yeah.
So you had said that, to set it up, you can have it be so that 50% of the assets or whatever way in the special needs. But you mentioned that was in the will, you also set that up in the trust.
Yes,
Okay.
preferably a trust.
Okay.
You know, uh, unless you have only $20,000 to your name, I'm going to tell you, I'm going to say, let's do a trust. You never know. You might get the lottery. Now your trust is ready to go. Yeah, so either from your will or from your trust at your death, or you can create it right now and put money in it right now. Yeah.
See, it's a third-party trust, they have, what's the maximum amount that you give the beneficiary?
Every penny you have.
But I don't need the amount you put in the trust, what I need is the trustee
Oh, the distribution.
gives money to the beneficiary. How much do they give without the beneficiary being paid?
Exactly. So a beneficiary, disabled beneficiary on SSI or Medi-Cal can only have $2,000 in their pocket. They can own a house, and they can own a car and jewelry, a burial plot, and a burial fund. That's about it.
But that $2,000
If they spend it, that's okay, as long as you're not spending it on something that Medi-Cal or SSI is paying for. Even still, SSI, what do you get? $820 a month, something like that. And you're supposed to only use that. And I wasn't going to make a public benefit seminar today, but SSI is for food and shelter only. If someone pays for your shelter, let's say coming out of the trust, they pay $1,500 of rent for an apartment near a bus station, near your doctor, near whatever you need, then SSI is going to be reduced by approximately 1/3, a couple $100. But that may be entirely worth it, especially if the trust has that money. A lot of people used to write trusts saying you can only spend things that are allowable, like you can't spend it on food and housing. But we make it that the goal is to supplement their public benefits. But at the trustee's discretion, you can make their life better if, hopefully you're making a good decision. So there's lots of things you can use the money for. You can buy a computer, a telephone, furniture, cable TV, entertainment, transportation, that kind of thing. Oh, wow, lots of questions. Right back there. Yeah.
I understand about the distribution because of those benefits also apply for the and if so, what are
Okay, so SSDI, if you have a certain amount of income on SSDI, then you don't qualify. But in terms of assets, it's unlimited. You don't really need a special needs trust for SSDI unless you're trying to stay on Medi-Cal because you really don't have money. You need Medi-Cal to pay your co-pays. So now you don't want the person on Medi-Cal, they're on SSI, Medicare, no problem, buy them whatever you want. But once they're on Medi-Cal now, they're a three-way user, then they can't have more than $2,000 at the end of the month. You can give them money and they can spend it. And they can buy things, or you can buy things for them. Section 8, I'll tell you, my clients never get into Section 8, so I'm not as familiar with Section 8. So I know it used to be if you had too many assets, then they would impute interest. And so they would generate 2% interest on it, and they would call that income. And then depending on your income is how much their subsidy is for your housing rent. I don't know that Section 8 has an asset limit. Does somebody know that? I don't know that. I don't think they do. Yeah.
So, like one of the things that we have, about the group, when you take it, something that's still in your name, it's not part of the $2,000, so. from
Right.
the trust, if you go by the ticket, it doesn't
So she's quite right. She knows that if I'm the trustee of a trust and I have a disabled beneficiary, I can't give them cash. If they're on SSI, dollar for dollar, they're going to reduce your SSI benefits. If I give them $800 cash, their SSI go to zero. If you go to zero on SSI, you lose your Medi-Cal. So you don't want to do that. But if they can go on a vacation, you pay American Airlines for the ticket. And if necessary, you can buy a ticket for a companion because they can't travel without a companion. So you can do that. It used to be the money could be only spent for the sole benefit of the beneficiary, but in this last year that got expanded. Transportation, a companion and transportation now is one of those things. Or if you go to Disneyland, you can buy a Disneyland ticket for you and the companion. Not all your brothers and sisters, not your friends, just this necessary companion. Yeah.
So the other hand, I don't know if you're gonna hold it, but so I create a special needs trust. Now going around to figure out how to money with my son works. So what I running into is I have first party special needs trust.
It,
Okay, that's great.
it's his money.
Right. And
You're the trustee.
yeah. And then third party is not creating it fast.
Right.
But one of the things, when he's working, and I'm kind of collecting his money before it leaves in special trust, I'm holding it in one area. So what I keep running into, if Chase Bank maybe will do it after this trust, Wells Fargo is but you no, you cannot have special trust as pay on death or transfer of death.
No, because the trust terms themselves dictate where. So your bank account must be titled in you, trustee of Sons Trust dated. That's the name of the bank account.
But I'm trying to have a thing before I transfer
Oh,
special needs trust.
so it would be in his name then. It's his money.
Well,
You can't give.
really, I have it, so right now what I have is my I want to transfer that, which is that one.
Well, so it's his income. It's his income. He's going to pay income taxes on it.
Right.
He is then putting it into the trust, the first party trust, not you.
Right. I'm just
So what, can he not have a bank account in his name?
no, he can't, but yeah. And I think you're actually before I put in the special needs trust, I'm just trying to put it someplace I can transfer it over.
Well, there's probably one or two ways to deal with that. Can I talk to you afterwards? Because that's getting beyond, yeah. Okay, I'm running out of time. I'm going to keep going. I want to get to a couple, and if any questions, let's just wait. All right, no reimbursement, others can contribute. The trustee does have to be knowledgeable about how to handle the trust. All three of these trusts, the disabled beneficiary cannot be cannot control where the assets go. No power to revoke or amend the trust. They cannot ever be the trustee, and they cannot direct the use of the trust. It's always up to the trustee. The trustee can have an advisory committee to help them, so a trustee can be an individual, a professional, like a private fiduciary, a bank, or the pooled trust. You can have provisions in the trust that there's a trust protector who can fire the trustee and make minor changes if the law changes. The trust will direct the trustee to make sure that they're cognizant of the rules. And whoever creates a trust can name the beneficiary, and there can be an advisory committee. That's usually with developmentally disabled children. So you use these trusts to improve the quality of a disabled person's life. So we talked about SSI benefits can be reduced if you use money for food and shelter, but that's okay. Maybe it's okay. Give them cash. You're supposed to report it. Their benefits will be reduced. That doesn't always happen. And the trustee can pay, to your point, directly to all the vendors that don't create ineligibility. here's some things that when you're on Medi-Cal and SSI that you can pay for. The list is really quite large. You can have a car, you can own a car, you actually can own a house. It's considered an exempt asset. But whoever has that house for this child, put it in the trust, otherwise it will be subject to payback. Appliances, computer, glasses, house, legal fees, pets, supplies, entertainment, storage units, musical instruments, fitness equipment, travel, tickets, etc. If you want this list, I can email it to you. So let me talk about Able Camp. What time is it? Oh, so I'm leaving only 10 minutes for Gary. Yikes. An Able account is a new thing. It's for the disabled person. It's a step in the right direction. It's a teeny tiny ridiculous step, but it's a step. If your child earns money and they want to, they can put that into an Able account. Whoever is doing it must have been deemed disabled before age 26. That's a key thing. Once that money goes in there, it can be spent by the disabled beneficiary on anything. And it will not anything, almost anything, and it will not be counted as a reduction of your SSI or any other penalty. It's not free, but it's free use money with no penalty. If you're on SSI, SSDI, or Medi-Cal, you automatically qualify. You can qualify other ways by your doctor just saying you have a disability. If you know you have this disability, you know there's a doctor's letter, you don't have to find it, you can self-certify until you're audited if that ever happens. But you can only have one of these counts. It can only have $15,000, although just this year they added up to an additional $12,000 of earned income. It must be set up in a state program. They invested in 3 or 4 funds. You don't have any control over that. California's is not in place yet. It's going to be called Cal Able, and you can just Google that, Cal Able, and it'll send you to an Ohio state plan. You can use any state's plan. Right now, the maximum is $100,000. This is a good thing. Let's say you get a lawsuit, you get $50,000. You can take $15,000 of it this year. Each year, you can only put $15,000 in and shield that money. If you have a young disabled child, you, the parent, can put $15,000 in a year, and by the time they're an adult, they'll have quite, something, more than nothing. It could pay for daily living expenses, housing, food and shelter, healthcare, transportation, almost that same list. You can just Google California Able or Disability DB 101 California. That's the big website if you want it. What's next? Gary. Oh. California Able account, just Google that. You'll get there. All right, I'm going to let Gary talk. Can we give him 15 minutes? Will you guys stay an extra 5 minutes?
I don't know how long it's going to take.
Oh, I'll go fast.
So I need a microphone.
You want this? Is this working or is it awkward?
This one works.
Oh, all right, you can have that. I will be around for questions afterwards. I don't know how long you guys stay.
I will too, since we're driving together.
And I'm going to leave to get a drink.
So Barbara's talked about estate planning, several of these tools that are available, the trust, the will, the advanced healthcare directive, durable power of attorney. She mentioned sometimes if you haven't done that planning, you could end up with some other legal requirements, whether it be probate in the case of a decedent estate, could be a conservatorship, I have the clicker here. If there hasn't been planning and you haven't named someone within the advanced healthcare directive as the agent, you might have a need for if someone becomes disabled. What I'm going to talk about is some other resource that you might call upon if you need somebody to serve to do that administration, to serve as that agent, to serve as that trustee. Oh, Let's see what.
Going the wrong way.
So I was going to answer a couple of questions here. What is a fiduciary? What does a fiduciary do? What the qualifications are, because fiduciaries are licensed by the state of California now. It's relatively new. That happened in 2006. What kind of rules do we follow, and why you might decide to choose one. And I'm also going to talk about a couple of different organizations. One is the California Fiduciaries Bureau, which actually provides licensing and regulatory oversight over fiduciaries, as well as a professional association, which I belong to, the Professional Fiduciaries Association of California. And it's there for providing education and standards of performance, and can be a resource to the public to find a fiduciary if that's what you decide you want to do. So who here has had some familiarity or dealt with professional fiduciaries? Anybody? Okay, good. So what is a fiduciary? Well, fiduciary in the most generic sense is a position of trust. Somebody who is responsible for someone or something. Under the the Professional Fiduciaries Act, it's defined as follows. A professional fiduciary is an individual who is entrusted property or power for the benefit of another. He or she serves vulnerable populations such as elderly or those who can no longer care for themselves, and is a neutral, objective party that provides overall care for the client. So as you know, as Barbara talked about all these different tools for managing an estate, there are all these different roles to play, hats to wear, and a professional fiduciary can wear one or more of those at any given time. They can serve as a trustee, basically stepping into the shoes of the settler, if the settler is no longer able to do that, if there's incapacity or there's or death. They can be appointed by the court as a conservator of the person or the estate or both. A guardian, similar to conservatorship in California, but dealing with minors. Could serve as that agent for the durable power of attorney or the advanced healthcare directive. They can be a representative payee for Social Security, for the Veterans Administration. Sometimes they take on a role less total responsibility, but help with someone who needs help balancing a checkbook or preparing bills and reviewing things, and just works with clients. And they can, in the case of a probate, they can serve as the executor, the executrix, or special administrator if that's the need. So those are the various roles. In terms of what they do, they do the same thing that you as your own trustee or a family member who you might appoint would do to handle and administer those various instruments. It's everything from managing or provide or arranging for care, housing, medical care needs, making medical decisions if need be, even end of life if they're serving as the agent under advanced healthcare directive, overseeing and making sure the public benefits are right and everything has been applied for, and in helping to maximize that. They handle all the investments from the house, if there's real estate, if there's portfolio, whatever it might be. They manage all of the bill pay, the banking.
They work with other professionals too, though.
Yeah, and so if a fiduciary has certain areas of expertise, they're going to focus on that. But just like you or any other trustee might bring in trusted advisors, whether they be CPAs for doing taxes, or an attorney, or a wealth manager for managing portfolio. They basically step into the shoes of the trust, of the settlor, the previous trustee, and handle those affairs, all carrying out the wishes, instructions of the trust. So I mentioned licensing. That is a relatively new thing. The legislation was passed in 2006. Licensing started in 2008. Currently, California is one of the few states that has that. We've sort of led the country in this area. Prior to that, there was probably less oversight on fiduciaries than there was under dog groomers, frankly. So they passed rules here that that the Bureau follows in processing applications, and then doing annual reviews and oversight and enforcement in some cases. So to be a professional fiduciary here in California, and you actually need to be one if you are not a family member and you are managing more than 2 trusts or 2 conservatorships. You actually have to be licensed. Unfortunately, there are folks out there that are practicing without a license, and the Bureau is looking for them. But this is all for consumer protection. So 21 years of age, U.S. citizen, or are being legally admitted. There's minimum education requirements, either a 4-year degree or a 2-year degree with 3 years of professional fiduciary experience working under another fiduciary, or with, if no degree, 5 years of background, even to sit for the exam. There's criminal background check. They use the live scan, and they look at criminal background, no bankruptcies. There's education, both upfront and ongoing. So prior to even sitting for the exam, you have to have taken 30 hours of education, and then there's fees. On an annual basis, there's continuing education, as with a lot of other professions, attorneys, CPAs, whatever. And there's a minimum of 15 hours that cover a wide, the range of activities and topics from investments and trust to care and learning about medical decision making and everything in between. The Bureau maintains a database of all the cases that licensees have. You do that initially, and that's updated every year. You have to report which new clients you have and which clients you've completed, and so they always know what all your matters are. And that's, again, for the protection of the public. So in terms of rules here, obviously going to be following the terms of the trust and take that very seriously. But then beyond that, and sometimes the trust is silent, you have all the other legal codes, the probate code and a lot of its components as it relates to investments and other codes of standards of business practice under the Fiduciaries Act. And then we have professional codes as well. Both PFAC, which is in fact a state affiliate of a national organization called NGA, National Guardianship Association. Guardian is used generically. In California, we use that to refer to responsibility over minors, but many states use that term for all, where we would use conservatorship. They refer to them as guardianships or guardians. So some of the most important values are recognizing and never forgetting that the client is the primary responsibility, having respect for that client. That's my cell. Can you believe that? no discrimination, and lots of elements of professional integrity, and maintaining competence in terms of skills and knowledge here. So why would you choose one? Well, I will tell you, I personally think if there is someone in the family or a close friend who can handle the affairs, that could very well be the best option. In fact, I can tell you that's how I got my start, was in my own family, stepping up when my folks became ill and passed away. And that's true for a lot of my colleagues. But sometimes there's one or more reasons why that's just not necessarily going to be the best thing to do. You need to look at each situation. So if you're looking at who you're going to name as a successor for your own trust, and you have children, you need to think about whether or not you want to select one of them, or maybe two of them, and sometimes two or more can create other problems where you have conflicts with co-trustees. But having one who's both a trustee for all of the siblings, but also a beneficiary, there's potential conflict that you can see there. Sometimes there's history of differences between families. Sometimes you have blended families, and you've got kids by both marriage. Sometimes there's somebody who's really capable, but they may be 3,000 miles away, or they have a family of their own, and they just don't have the time to commit to that. So, each situation is different, and you need to assess that. I mean, it's worth considering family, but that's not always possible. So, on the flip side, if you're looking at a professional, and there are other options as well. So there are, some of you probably are familiar, there are trust companies or banks that perform this function as well. And there's pluses and minuses to that as well. We can talk about that if you're interested. But you're looking for someone who's really going to be an objective third party who's going to carry out your wishes. I mean, I feel very strongly that that I do step into the shoes of my clients when I do this, and I try very hard to understand what their values and wishes were. The more time I can spend with them before I have to step in and can learn about the family and the history and what's important to them, and if there are special non-fungible assets, heirlooms or whatever, and they want them to go in particular places, the better I can just carry out their wishes. So if it's an opportunity, if it's the right fit, to find someone who will carry out your wishes, whether it deals with your personal care, medical decision making, or distribution of your assets. Yes.
Well, I was trying to get a sense of like what I do right now. I don't know if you have food or boat shopping, therapist.
Yeah.
How does all those day-to-day things
Right.
over and above
Right. Right. So different practices may have different functions or individuals within them as employees. My particular practice is a solo practice, but I do retain and bring in outside resources when they're needed. Whether it's the gardener or somebody to do do maintenance on the house, or if it's caregiving or running errands or whatever, we hire folks. So I hire caregivers for certain clients, and sometimes I'm hiring case managers to oversee the caregivers and to accompany them to medical appointments. And sometimes I may be serving, say, as a trustee, and there's a family member who is the agent under the advanced health care, and they might be in Australia. And so I'll bring in a geriatric care manager to be the eyes and ears, boots on the ground, report both to me and to the family member what's going on. So, there's tremendous flexibility in terms of organizing things to meet your, any given client's needs. Of course, budget and resources come into that as well. But that any of those kinds of things can and are addressed.
Matt, just bring up a quick question. Is this basically an hourly type card or like or how?
So, fiduciaries are all independent individuals, business people, and they have their own fee structures, and they vary. Some have fixed fees on a monthly basis. Some charge hourly. Some charge as a percentage of assets, depending on what's going on. So again, every fiduciary has a different way that they work. Yes.
Is there a list of fiduciaries specified in helping them?
Yeah. So let me go one more slide here. What happened here?
Shut it off. No, you shut it off.
Can I do it from the?
Are you the guy? Did we shut it off?
Okay. So there. So my last slide here, which will relate to your question. So I mentioned two organizations. There's the Professional Fiduciary Bureau, which has a website, www.fiduciary.ca.gov. And as I mentioned, that's the regulatory agency that oversees professional fiduciaries, that does licensing, that does enforcement and all. You can go to that website and do a search there on fiduciaries, and you could look at people's, there's some very basic information in terms of the assets under management and whether or not they've been subject to any disciplinary action. The other organization is the professional association that I belong to, PFAC, Professional Fiduciaries Association of California. The website is www.pfac-pro.org. And on the homepage, you'll find a Find a Fiduciary link there, and there's a search function, and you can go in and you can search by city of practice, by county, by areas of specialization, and then there are links to, and contact information and links to reach out to them. But one of the best, I would tell you that one of the best sources of information may very well be your attorney. Attorneys will be very familiar with a number of fiduciaries and quite often will give referrals to their clients. Yes, sir. So you as the settler of your, but I'm coming back to the contract. Okay, so you have a trust. And that trust has terms in it. And you can dictate the succession mechanism. You can identify who's first in line, who's second in line, who's third in line. And if none of those folks are available, you can create a mechanism. You can work with your attorney. You can create a mechanism that will determine how the next one would be selected. It could be a partner in that firm who will select a professional fiduciary in good standing. I mean, there's any number of schemes out there, but you can control that.
Okay, Gary. Karen has just asked that
Okay.
if it's past time, if you want to leave, feel free to leave. We're going to stay and answer questions, so don't feel bad if you have to go.
And I thought you were going to tell me I was practicing law and I shouldn't be doing that.
I wasn't listening. Oh, here.
Oh.
Is your question for him? I mean, we'll do it as a group if you want to.
So there are other answers, but the settler, you have some control over that.
Two quick questions. Basically, if I am doing part of it,
This is the end of my cards. I'm sorry, this is all I have. But she's going to put my slides up there.
Yeah, that's possible. It gets complicated because of authority and lack of severability of liability issues. But, you know, fiduciaries do work on a consulting basis as well.
So right
So
now-
that there are a lot of, yeah,
in a third party.
In the third party,
You
right.
can, it's just, you might want to talk about whether you should or not.
well, so
I mean,
if it's a
save your
court
money-
supervised
save money
matter,
by
and it
doing
could
it
be a
later.
conservatorship for sure,
It's
but
the last of my
it could be a
cards.
trust, there's an accounting that has to be done and presented to the court, and it goes to all the
Yeah.
everyone who has an interest
I ran
in that, and everybody can comment and
Isn't that
raise
amazing?
questions, and it's a
She's gonna put
review.
my slides
If
on your
if it's not court supervised,
Yeah.
the trust typically
Let's say we set up
states
a
what
special needs
the
fund.
counting
I don't have any more
requirement,
cards.
what the duty of the trustee is. That should be specified in the trust document.
That trust was allowed to purchase a house if they became able to
You got to talk to
live in
the lawyer.
a house, or does
I,
that
it's
have to
it's
be?
brand
I
new.
just
We don't
ran
even
out.
have the
Or does
vetting.
that have to-
They're
They're
gonna put the
just
slides
coming.
on your website.